Welcome to the Challa Law Weekly Webinars. It is March 23rd, and we are here to help clarify some of the confusing issues that you all probably been having on interfiling and questions of EB-5. Now, remember, whenever you're dealing with a government agency, the answers are not going to be crystal clear. It would be wonderful if they were, but we are going to try to provide clarity in these matters with how the law is and prescribe some best practices as a result. So with that, let's get started. And as usual, we will have Q&A, after the session. There we go. And see if we got it. Wait a few minutes to see how many folks have joined. We've got a good crowd today. Good. And so the first topic is interfiling, the nuances of it. So let's get started. Interfiling, if we want to talk about, I am trying to see if I do this. Oh, no. Okay. No, I can't do it that way. I was trying to do something so I could see. So if we start with the very basic premise, 8 CFR 2045E states that an individual once assigned a priority date by an approved employment visa petition is entitled to keep that priority date. So when is it once assigned? It's assigned when the I-140 is approved for employment-based cases. So once the I-140 is approved, that priority date vests with the individual. That means you get to keep it, unless there's been a subsequent finding of fraud or misrepresentation. That's the only way you lose it. Moreover, the applicable regulations, 214.5E provides that if an individual is a beneficiary of more than one petition, he or she will be assigned to the earliest priority date available. The regulation provides specifically that the retention of Section 203B1, 2, or 3 priority date, a petition approved on behalf of a beneficiary pursuant to an employment-based priority, it accords the alien the priority date of the earliest approved petition for any subsequently filed petitions. So that's just about priority date vesting with the individual. So that's the basic premise of all of this, right? You've got various classifications. The priority date remains the same. The issue has been the movement of EB2 and EB3. Okay. The service cannot transfer a priority date from one individual to another. The priority date is specific to the individual. However, a derivative beneficiary is entitled to the priority date of his or her principal. What does that mean? That means a lot of confusion has been, and they call it interfiling. The husband may have a priority date under EB2 for a specific time period, 2014, and his spouse, who is a derivative, has a priority date of EB3, which is an earlier priority date. It's not that you're interfiling your spouse's priority date to the existing petition. It is you are leveraging what is called cross-chargeability. So you are able to leverage the priority date of the derivative spouse if that is more favorable. The applicant can request a new priority date to be applied to an existing petition. So there's no format, although there have been recently some suggestions as to how the process can, how they can comply with the process. But nevertheless, this interfiling is not set forth in regulation. It is set forth in agency directives, which is why there's no clear standard process. And the applicant must be able to demonstrate that he's continuously maintained status for eligibility for the application that was originally filed. And there can be no break in eligibility based upon the first petition. And you have this, but you also have the context of AC 21, right? Which allows you to port to a new employer once the I-140 has been approved and the adjustment's been pending for 360 days. So the USCIS policy manual outlines how you can interfile. An adjustment whose application is based on a particular immigrant category occasionally prefers to have the pending application considered under another category. So some of the examples they include are an applicant who originally filed for an adjustment of status for a pending approved employment-based petition and later marries a US citizen and now prefers to adjust based on a family-based. So this way, once the I-130 is approved, you can use that and not have to file a new adjustment as the basis of your, to interfile as a basis of your adjustment of status. An applicant who originally applied to adjust as a spouse of a US citizen, but now prefers to adjust under an employment-based category in order to avoid the conditional residence requirements. Remember that if you are married to a US citizen and you obtain adjustment of status pursuant to that, you're given a conditional permanent resident status. Let's say you had an employment-based process that was suddenly became current. You can take your employment-based approval and ask to adjust to that, so you don't have to obtain the conditional permanent residence. That is another way. An applicant whose adjustment is concurrently pending with an employment-based category and subsequently had another employment-based category filed by a different or future employer in a different preference category. And I think I go over this in length right here. So an applicant who's applied for an adjustment concurrently with a pending employment base in one preference category and subsequently had another employment based filed by a future employer in a different preference category. And in fact, one of the very first memos that came out about this several years ago, I think it was the Michael Pearson memo in 2000, Pearson clearly stated that permanent residence is for future employment. And so it doesn't have to be that the employee currently works for the that particular classification, but they just have to have the present intent to work for them in the future. So that's solidified in the USCIS current policy memo. And I'm going to explain why that's relevant. And then, of course, there's diversity lottery and other things. The decision to grant or deny a transfer request is always discretionary, and there's several factors to consider when determining to grant a transfer request. You must remember that the eligibility for the substituted category, that the individual must have that eligibility. So, evidence required can be found on the adjustment application's filing instructions, but the transfer should be treated as if it were a new filing, and the application should provide the necessary documentation to establish eligibility for the new adjustment category. And that would be, the approval notice, some of the other supporting documents, and so forth. And the visa must be immediately available. When an applicant requests for an interfiling, the classification must be current. And let's talk a little bit about the implications of this and why some of these things are an issue. So let me try to piece this all together for you in different situations. And I would say the two salient issues are Number one, can you interfile for, can you interfile with an employer that you previously worked for? Can you interfile with your new employer? And the answer to that is back to that slide where I said, it doesn't have to be your current employer, but you have to have the present intent to work for that employer after your adjustment has been filed. So why is it that a lot of attorneys that are representing the employer are not willing to file the interfiling with the previous employer? Because they're representing your current employer. So why would they file something where you have to affirm that you intend to work for that previous employer? You've got the present intent to work for that previous employer once the permanent residence is approved. And like I said, this is clearly solidified. So it's not really that you can't, it's that you can if that's who you're going to work for in the future. Secondly, clearly you can, if your current employer, and this is all the situation, we're talking about a situation where you filed an I-140 and I-485. You have since ported pursuant to AC 21. And when you filed, you downgraded a new petition into EB3. Now you had an EB2 with that previous employer, and you want to know if you can interfile that. If you have, every time you file an I-140, it's as if you're filing a new I-140, even if it's pursuant to an interfiling. Now remember, the EB2 has to be current. One change that has been made is that your previous petition does not have to be approved in order for you to leverage the filing. However, number one, if that petition is somehow denied, that was the basis of your adjustment filing, there is that risk. So, I would either get it premiumed and get it approved, even though they don't require it, because that was the basis of your adjustment, even if you're interfiling. Number two, if you want to interfile with your previous employer's I-140 that is in another classification, you can do so, but you can only do it if you have the present intent to work for that previous employer once the I-140 is approved. Once the adjustment is approved and you've got a green card. Number two, every time you attach a new I-140 in the interfiling process, you are triggering the new 180 days for AC 21. That's important to remember. Number three, the new guidelines provide that interfilings, how you interfile, can be filed with an I-485J at that I-485J address location, filing location. If there's no I-485J involved, then you would file just with the service center. What does that mean? Let's say in that same example I gave you, you filed an EB3, you downgraded with a new petition on an EB3 2 years ago and filed a concurrent adjustment. When the I-140 was approved and the I-485 was pending for 180 days, you've now changed employers. When you changed employers, you filed an I-485J. Maybe this new employer started the permanent residence process for you as well under EB2. Now that is approved. Well, if you want to if that EB2 now renders you current based on your previous priority date, right? Then you would want to interfile that if it is current. You've already filed an I-485J for your new employer. So you don't really need that at this point. So then you would file at the service center that has your current petition. If, however, you are planning on going back to your previous employer, present intent to return to previous employer. Once the petition is approved, then you're going to have to file an I-45J. And remember, I-45Js, both the employer and the employee are affirming to a federal agency that there is a bona fide job offer, that the terms and conditions of the Perm, would still apply. So, you still met the eligibility requirements. So you got to make sure that, whatever was represented on the I-140 in terms of job location and other things are still valid. And then you would be able to leverage that particular process. And the fact that I think it's great that a visa must be immediately available is there has been some clatter that the new interfiling will replace the previous. I'm not necessarily sure that that is. I think it depends on the particular circumstances. I think it depends on whether you're using another employer or your current employer. I think there are a lot of gray areas there. But the benefit of filing when a visa when you are current is that that at least that with this, whatever you're presently filing, that you're availing yourself of the process that would allow you to, hopefully quickly obtain your immigration objective. Now, the other thing is for those who have CSPA issues, remember, if you file your I-140 when you are current, that locks the CSP date of the child. So that's another benefit for filing under this manner. So I know that's a lot that we covered, and all of it is not cut and dry. As you know, with immigration, nothing is cut and dry. So you have to look at the totality of the situation and look at the fact-specific case. But I wanted to debunk some of the issues that are out there, whether it's the spouse interfiling, which is really a cross-chargeability benefit, or whether the issue of filing for interfiling with a approved petition for a future employer or a different employer than you have on file. So I hope those issues were clarified. The last debunking of today, let's talk about the whole EB-5 concurrent AOS issue. I know there's a lot of confusion as to how this is laid out, and it may be that this is just my interpretation, and it may be that USCIS clarifies it either one way or another. But how it is written is if an approval of a petition for classification under 203B5, EB-5, would make a visa immediately available. That means it would be current, and for the most part it is. The alien beneficiary's application for adjustment of status under this section shall be considered properly filed, whether the application is submitted concurrently with or subsequent to the visa petition. So the effective date is, and I don't know why the text kind of put numbers in, is when the bill was signed. So President Biden signed the bill. And so it, even in the discussion, what we're looking at now is we are reviewing the congressional records, because when there's some ambiguity in any legislation, you look to see what did Congress discuss. It would seem to me the way that it was written, because or subsequent to the visa petition, that if something's pending, that you should be able to file it with that pending application. It is not clear, but I read it as effective from the day President Biden signed the bill, people are eligible to file for adjustment of status. It would seem awkward to me that they would foreclose all those people who have already filed and have been pending, and in fact, have been in this, where their petitions have been held in abeyance for so long. But we're seeking clarification on that. There has not been a lot written about it. I know people take the effective date of the act to say that it would apply to only those petitions going forward. But in my experience, when Congress has meant that is only effective for those applications going forward, they say that. So I read it to mean that the adjustment of status, the ability to file that, is effective from the date President Biden signed the bill. But I don't think it's limited to only those people that file subsequent to the enactment. Otherwise, they would have, I think they would have said that. So that is our debunking for today. And I will look for Shaker Challa to come up and moderate some of the questions that we have. You know, I want to say hello to all those people on YouTube. Thank you for joining. I want to thank all those people, new folks that have joined. Let me ask, I always ask this question sometimes. With a show of hands, how many of you are new? Can you raise your hand if you're new to our, great, we've got a couple of new folks. Well, welcome. Thank you for joining. And for all of you who have been, you know, attending our webinar every week, thank you for, you know, for all your support in that realm. So Shaker, I guess you are.
Good afternoon, Lakshmi, and good afternoon, everybody. Glad to see you all.
I can't hear you.
Can anybody hear me? They say they can hear me. They all are saying they can hear. Maybe it's your setting.
Maybe you want to call in. Oh, is it me? You think it's me? Maybe it's me. Maybe it's not you. Hold on. Talk now.
Yeah. Can you hear?
Can everyone else hear you? Maybe it's my settings. So go ahead and ask, and I'll try to. Make sure that.
Do you have any, can't talk to you, but.
Hello? Say something.
Hello.
Yeah. Somehow my computer is connecting to a speaker that is not even on my system.
Well, sometimes if you had connected earlier,
Nope.
you know.
I haven't connected to anything.
Anyway, let's go. And seeing if there's anything on chat. All right, there's a question from chat. Raghu Krishna. In order to interfile to EB2, will the pending E3 I-140 application needs to be approved? Will pending EB3 I-140 affect interfiling anyway?
Well, you know, the new clarification I think that has been out is that, and it was, let's see if I can find it. It is, it was issued on 3/17, that they are encouraging people to file for employment-based EB2 categories. And I think the recent change has been, and Ashley, correct me if I'm wrong, Ashley's on the call, that you can file it for pending petitions. Here is where I have a concern about that. I think you should try to file an upgrade and either wait for the upgrade or file it concurrently with the upgrade, because the original petition is the petition that is the basis for your adjustment. If that is denied, your interfiling, if you will be problematic. So that's what I would do. I would wait for, even though you can do it, I wouldn't do it.
I think Ashley had confirmed what you were asking, pending or approved I-140.
Right.
Okay. Next question again from, I'll take it from the Q&A box. So I'm taking questions in the order they come in, the timestamp. So just in case if you're wondering. Karthik Rajashekharan is asking, I moved to new employer and filed 485J with AC21. I wanted to refile using existing employer EB2 I-140 while with the current company. My attorney replied as below. Our response remains the same. Yes, you may refile your I-485 based on the approved EB2 I-140. We will submit an I-485J signed by your current employer with the refiling. In our cover letter, we will request USCIS to consolidate the two I-485s. Is it correct?
But why, you move to a new employer, I-45J. When you say, I want to refile using my existing employer while with the current company, if you already adequately ported pursuant to AC 21, which is why you filed the I-485J, and you now with your new current employer have an approved EB2 I-140, why are you filing a new adjustment? Why aren't you just interfiling your new EB2 I-140 and submitting an I-485J?
Karthik, you can answer in the chat.
Yeah, because you don't need to file. The whole idea is with interfiling is you don't need to file a new I-485. They're pretty expensive. You can, and I think in some instances it may make sense. Let's say, for example, you filed a downgrade and you've ported to, right now your EB2 I-140 is with your current employer. Let's say you have an EB2 with your previous employer. And instead of interfiling, I think as a strategy measure, you file a new, and the lawyer for your current employer is not willing to interfile.
He answered in the Q&A. He says, I don't have a current company I-140 EB2, but previous company.
Oh, okay. Yes. Then I think what your attorney suggested is correct. But remember, you can't file an I-485J after you file. If you file a new EB2 I-140 I-485, you're going to have to wait until your I-485 has been pending for 180 days before you submit the I-485J.
All right. Let's go to an anonymous attendee. I have pending Perm in EB3 with new employer. My I-140 was approved in EB2 with past employer. Now my EB2 DAF is current. Do I have any options or should I wait for the EB3 PD December 2013 to current? I don't think previous employer will file.
If you don't think the previous employer will, remember, you have to have the present intent to work with that previous employer. So if they're not going to file, then the issue is moot, right?
All right. Joseph Matthew is asking, hi, I'm currently in the US on L2 EAD. My employer applied H1B and I got it approved. Status changed to H1B. For the stamping, can it be done in Canada or would I have to do it in India? Please advise.
You know, I would advise, and Matthew, if you email us at info@challalaw.com, we'll send you a contact for processing in Mexico. There is someone that has a concierge service that will take you through it. And between Canada and Mexico, I would rather go to Mexico to process than Canada, as long as there's no issues with your H-1B. You know, you have all the contracts, you've been on payroll. That's where I would suggest that you go.
All right. Next one from another AA. Can you have multiple I-485s, one in EB2 and one in EB3, and stay in both the lanes? Thank you.
Great question. Absolutely. Where people get confused is the regulations state you can only adjust with one I-140. That's true. So what the USCIS, it doesn't say you can't file multiple adjustments. So what the USCIS will do is they will reach out to you when it's close to adjudication and say, which one do you want to withdraw? So yes, you can have two. And in fact, if you're going to file, instead of interfiling, if you've got a previous, an I-45, I mean, an I-140 with a previous employer, and you've got the present intent to file the I-140 with the previous employer, I mean, work for the previous employer once the 45 is approved, and that previous employer is willing to file an I-485J, I would rather you file a new I-485 than try to interfile.
All right. I just want to say, and he says he wants to stay in both lanes.
You could stay in both lanes until the
Yeah.
USCIS tells you to choose a lane.
But I was just reminded of the hearing of Justice Judge Jackson, who continuously, repeatedly said yesterday she wants to stay in her lane.
Right.
So that's good.
Yes, she
The
wants
next
to.
question.
It's a separation of powers. She wants to be. She doesn't want to be an activist judge. She just wants to stay in her role as a judiciary.
Yeah, that was pretty good. Next question is says Mahi ma'am. Mahi, that is Mahendra Singh Dhoni's nickname, Mahi. Lakshmi Challa, your first time you got Mahi ma'am. So I don't know who
wow.
that is. My priority date in EB2 is October 14th. I have approved a H-1B visa till 2024. If my priority date becomes current as the filing date is September 14th, can I apply or wait for final action date to be current? And can I travel and get H-1B visa stamped? If not, what all options I have since I have to travel to India in May?
When does her H-1B expire?
I have approved H-1B visa till 2024.
Okay. Yes, absolutely. You could travel on your H-1B while you have an adjustment pending because it's H's and L's are dual intent.
All right. Okay. Me just checking the. Okay. Next one. Karthik, of course, he clarified that. Joseph clarified. All right. This next one is from the chat. Anonymous had filed EB3 downgrade in October 2020, got GCEAD and my derivative H4 spouse used it in August 2021. Also in May 2021, we filed for H1 and H4 and H4 EAD extension, which got approved in September 2021 after spouse started using GCEAD. Is my wife on valid non-immigrant H4 status? If yes, can we file a new I-485 in EB2 now that the dates have moved?
Do you want, well, first of all, an H4 can work either on her EAD for her adjustment or her EAD for her H4, because she's not the principal applicant. So i.e., what that means is the status, H4 status, is not dependent on her, but on the spouse who's on the H1B. So she can work either way. It does not affect her adjustment of status. Why is it that you're filing a new I-485? What's the basis of your new I-485?
I think the person says, can we talk?
Email us, Mahi, at info@challalaw.com. And our folks, I'm sure, will post that up.
I think Mahi M is her or he or he or
it's
she.
Her name.
Yeah.
Yes, you got confused with the Mahi and the Maha.
Okay.
The Mahi and the Maha.
Can you file a new EB2 I-485 based on approved I-140 if the EB3 downgrade I-140 is pending?
Say that again.
Can you file a new EB2 I-485 based on approved I-140 if the EB3 downgrade I-140 is pending?
Yes. Especially if you're filing a new one. And I would suggest that because, like I said before, I think even though it's permissible to interfile with a pending I-140, I would feel uncomfortable doing that because if anything should happen to that pending I-140, then, you know, everything is kaput. So I wanted to take a second to ask all the folks, whether on YouTube or the ones joining our group, if you haven't already, we've got this wonderful forum for Hum. And for those who are Hindi speaking, you know, Hum means us. And it was a play on the forum word, which I hope you got. But it's clarity. And that's what I hope you thought we provided today, is clarity. And so what we're trying to do is take all the disparate information that may be out on the internet and try to break it down in a manner in which it's clear to you so you can make your immigration decisions. And this forum is a group of people that all are going through the immigration process. So it's a nice community to be a part of. And we chime in once in a while, so you will have our resources on there as well. If you are on your computer and you want to join me in or join us in the forum, you just have to put your iPhone up, put your camera on, and boom, you get a link. And if you're already part of our forum, why don't you put your phone up if you're on a computer and take the link to share with some of your friends. And if you are listening on your phone, then I'm sure Lainey will send the links in the chat. Now, for those of you who have not registered, especially my live folks, YouTube live folks, you know, this is a good way to find out when we're going to have the weekly webinars, because sometimes we have special webinars where there's a new topic or something that is time sensitive that comes up. So if you register, this is a good way that you can find out about when we're having this special topic webinars. Again, you put your iPhone up, you get the QR code. And if you've already registered, again, share it with your friends. The more people we have, the more instances and information we get about what everyone's going through, the more we can be a voice to all of you. So please share it, and let's grow this group. Let me see where, with the number of participants today, let's see if we can grow this by 25% next week. See if you can help me do that. And that would be a great way. You know, a lot of people send us notes saying, thank you, we appreciate all you do. That would be a way to show your appreciation for our efforts, is to help us grow this community. And then last, because we're going to have this today's session kind of made concise so that short topics are going to be on our YouTube channel. If you haven't subscribed to our YouTube channel, again, your phone, if you're on a computer, hit the link. If you're on your cell phone, and subscribe to our channel, because the only way you'll know when we update things, when we put in content that's critical for you, is if you subscribe. And if you've already subscribed, what am I about to say? Share it with your friends. Absolutely. That would be, it would make me feel really good. It would make my team feel really good for all the effort they put through. So I would just make that request for you. Just send it out to 3 people. Doom, that you know are going through it, and say, hey, check this out. I went to this. Only if you found it helpful. If you think our webinars are not helpful, then please don't share it. But if you do, and I guess for a lot of you that have been continuing to attend, you do find it helpful, then please, let's spread the word. So thank you again. And Lainey will share the links on the chat. That was my commercial break.
Good one. All right, we're going to continue. There's somebody who says he has difficulty trying to keep you in mute and listen. So my priority date is October 2014 EB2. The present filing date under EB2 is September 2014. I have a situation going on and I will have to go to India in May 2022. I have approved H-1B, but will need visa stamping on my visa when I go to India. I hear that after filing not to go to India, apply for AP, but that will take a long time and it is emergency to be in India. Please need your expertise.
You may want to try, I don't know what the dates are in Mexico now, but you can try Mexico. If you've previously had an H-1B in the past 2 years, you may be eligible for Dropbox. So you wouldn't have to get a new stamping. But those are the 2 options I would look for. Traveling on an H-1B while your adjustment is pending is not the problem. You don't have to wait. In other words, you don't have to wait for your AP. The issue is getting the visa stamping, right? So here are 2 ways. You may be eligible for Dropbox. And the other thing is, assessing the process of filing your visa in Mexico.
All right, next one from an AA. I'm staying in place A and working remotely for a client in place B. My LCA has my home address and also client's address. Wage level is based on B. Can I change client to another company located in place B without doing H-1B amendment, still working remotely from A?
Yeah, so your end client is changing, but your petitioner is the same and your location is the same. So yes, you can.
I have a request to make. Please post only one place. I know the YouTube folks and Facebook folks may not be able to use the Q&A and they probably put it in chat, but I see a lot of questions in both Q&A and chat. And it is confusing in the sense that I have to read and see, oh, I've already asked that on the air, and it's a little waste of time because that time I could use to ask another question online on the air, right? So I would appreciate that. If you believe me, we will answer all the questions. If you put twice, it will be tough. So please refrain from putting it both places. Thank you. Suresh Kugalakuntla is asking, downgraded to EB3 concurrent during October 2020. Priority date is March 2013. Company got acquired in January 2022. New company attorney is suggesting to amend EB2 I-140 as successor in interest and secure approval before interfiling to EB2. Can EB2 amendment be filed in premium? Also, can both EB2 and EB3 be amended with a single premium?
When you amend, and you have to amend for successor in interest, that means whatever was there previously will no longer be there. So let's say if you're amending and you're not changing the classification from EB2 to EB3, then that's fine. You're just amending that to reflect the successor in interest. So if you're going to do a downgrade, I wouldn't do it vis-a-vis the amendment. When you amend, you no longer have the original perm with you. So you can't file it in premium processing because the USCIS is going to have to request the perm from the Department of Labor, and they will not adjudicate it until they receive the perm.
Okay.
You can later upgrade to perm, and we did that successfully, I think 6 months, 7 months after we filed the amendment. I mean, not the amendment, but the concurrent filings, which also didn't have the perm.
Next question from an AA. Can you interfile with data filing being current and not FAD?
No, I think it was very clear that it stated, and I have to look back on that, that it must be current. So you must have a current priority date. And as I told you, I would suggest that because there could be circumstances where you want to make sure that they're not substituting it for a non-current date. So yes. The priority date. So it doesn't say that you have the eligibility to file. It clearly states the priority date must be current.
All right, next question from Hardik Panchal. With marriage-based green card application, if you file the advance parole document, how soon can they give the travel document to leave for India and get back?
Travel documents are taking a really long time. So if you've got a valid H or L visa, you can travel on that. But I think they're taking about 9 months. I think, yeah, about 9 months now. Anywhere from 8 to 12 months is the range.
Mahi M wants to thank you for all of the great informative webinars. Thank you, Mahi M. And also I will ignore your question since it was already answered. Karthik Rajashekaran is back. He wants clarification. Can you please answer again to my query? Sorry, I was not that clear. Did you mean I can refile at current new employer using existing company EB2 I-140? Is my understanding correct?
Didn't Karthik say, I've got to look at his,
his original question is, I moved to a new employer and filed 485J with AC21. I want to refile using existing employer EB2 I-140 while with the current company.
Right. So, you know,
his attorney replied.
Yeah. And so here is the thing, Karthik, that I'm understanding from your question. You ported to a new employer pursuant to AC21 with an I-140, I-485. Your previous employer has an EB2 approved. Your current employer's attorney suggested that you file the I-140 and I-485 for that employer, and you'd have to file an I-485J again, showing that you intend to work for that previous employer. You've got the present intent to work for that previous employer once it's approved. Your current employer will then wait. You didn't say this, but that's the only way they can do this. 6 months from the date of filing to file a new I-485J, merging both the adjustments. And I said that that was correct.
All right. Karthik, if you still want to additional clarification, send us an email, info@challalaw.com. Next one from an AA. I couldn't file in October 2020, but now I am in a position to apply for 2 different I-485 applications from current employer and another employer. How these 2 applications are processed and what stage I need to make my decision.
USCIS will tell you to when you want to make the decision. If you're filing 2 I-140s and 2 I-485s, remember when you're filing the I-140, you have to have the present intent to work for that employer. I don't know how you can have a present intent to work for 2 employers. I know when you file one and later you change your mind, you may file another I-140 and I-485. But I think filing them both at the same time negates the fact that you've got a present intent to work for that employer, because you couldn't if you file 2. That's the only thing I'd keep in mind.
Just another quick, Karthik says, I have no intent to work for the previous company.
I can't tell you what to do, Karthik. That's what the regulations state, that you can file for future employment. But anytime you file, you can't file just for trying to secure the benefit. Now, how are they going to enforce that? Truly speaking, they cannot enforce that. But I would not encourage you to file if you don't have that present intent. You can always change your mind because AC 21 allows you to change your mind. You know, once the I-140s have been approved and the 45 has been pending for 180 days and you're working for same or similar employment. But at the time you're filing, you have to have that present intent. And what I tell people is, you know, any email exchanges you have with your previous employer, anything where you can say that, you know, presently I intend, and later change your mind, that's fine. But something to demonstrate that you have that present intent to work for an employer you're currently not working for right now.
All right, I got 5 more questions and then we'll close. And if you have anybody who still wants to ask, please send us an email to info@challalaw.com. So next one is from another AA. I downgraded from EB2 to EB2. There must be some mistake, maybe EB3 to EB in October 2020. Now my EB2 date is current. I'm planning to request for interfile. If due to some reason I have to change job to new employer, what will happen to my status? Does new employer will have to file I-140 and 485 again?
No, I mean, once you interfile, you have to wait another 180 days, right? So you wait another 180 days and then you can change employers and your new employer will have to file an I-485J. But every time you attach a new I-140 to your 485, it triggers that AC 21 clock again.
Next question from the chat, Hari Sevugan. EB3 downgraded in October 2020. My PD is February 13, 2013. EB2 I-140 approved. So interfile to CA address. Should I also interfile to TSC or should I refile I-485 in EB2? Basically, would it help refile on top of interfile?
No, and they've clearly said that. If you're with the same employer, and there's no change in that. And with that same employer, you have both an EB2 and an EB3 because you filed a new EB3 when you filed your adjustment of status 2 years ago. As long as your EB2 is current, then you can interfile that, connecting that to your adjustment of status.
All right, next one from an AA. If I-140 EB3 downgrade is pending and H4 spouse has used GCEAD and primary is maintaining H1, and now EB2 is more favorable, can we file a new I-485 for both me and my spouse?
Can you read that again? Because I want to know if it's the spouse's.
If I-140 EB3 downgrade is pending and H4 spouse has used GCEAD and primary is maintaining H1, and now EB2 is more favorable, can we file a new I-485 for both me and the spouse?
Yeah, but why would you want to unless it's with another employer? If it's with your current employer and the EB3 downgrade I-485 is with that same employer, you could just simply interfile.
Next question, can we travel international on H-1B for Dropbox appointment while H-4 and EAD is pending? What happens to H-4 and EAD in progress? Can we update USCIS with updated I-94 after travel for the pending EAD and use the 180-day employment extension?
Yeah, I mean, once you're stamped, remember it goes through that village, and we've got a memo or the YouTube channel, I mean, the YouTube that we have on that issue. So yes, so what happens is when you travel, the extension should not be impacted. H's can travel while their extension is pending, but the EAD extension would be impacted. So you can travel, and if you've had a H-1B visa from that same country within the past 2 years, you can leverage Dropbox. And with the extended period, you would be eligible on the reentry for continuing to work on your EAD. And you'd have to refile once you come into the country.
Okay, I got 2 more questions. And like I requested, please don't put any more questions. You send an email. We'll be glad to answer. This next question is from chat. My EB3 I-140 is still pending. This is actually from Hunter. My EB3 I-140 is still pending, and I downgraded in 2020 October. My PD is July 2011. Should I refile or interfile? My employer won't allow premium processing of I-140 in EB3. Is okay to refile or interfile? Please help.
It's very fact specific, because I said the risk is with interfiling. If the I-140 is not approved, then the concern would be what happens if it gets denied. So on the safe side, what you may want to do is just file a new I-140, I-485. It's unfortunate that your employer won't let you premium, because now you're going to have to spend all that money on a new adjustment application. But that's what I would do. That's the prudent thing to do with the I-140 still pending. You are allowed to file, but I wouldn't do it.
Okay, this one, my case downgraded from EB2 to EB3 in October 2020. My EB2 date is current now. My EB2 was filed in 2013, and in 2018, company got split, and I became employer of new company, newly formed company with a new name. In this case, does interfile work or first EB2 I-140 need to be amended?
It's got to be amended.
Okay, this is the last question. And this question is on chat as well as on the Q&A box. Can I file two separate I-485s through concurrent? We answered that. Current and previous employers using their I-140. Let me repeat just in case. Can I file two separate I-485 through current and previous employers using their I-140?
Yeah, this is the one where I answered that every time you file an I-140, you're making a representation that you have the present intent to work for that employer once the adjustment has been approved and you're a permanent resident. You can't have the intent to work for two employers, right? So you can't file them at the same time, but if you file one and then change your mind and think you may have the present intent to work for the other one at a later date, you can do that.
That's about it from my side.
Great. Well, I want to thank you all again for joining. Join us next week for some more debunking and hot topics that we'll have. Please share our webinar information with your friends. It would be greatly appreciated. I want to thank my team for putting this together. Would not be able to do it without them. I want to thank our great moderator for moderating all these questions. And we will see you again next week, Wednesday, 12 p.m. Eastern Standard Time. Stay